Good afternoon. We're going to go ahead and start our program now. Please continue to enjoy your lunch. I'm glad that everyone is here and having a wonderful time. This has been a fantastic conference. And for those of you guys who didn't know, we'll be at the University of Nevada, Las Vegas next year. So put that on your calendar for the next big, contracts event. This afternoon, of course, we have more wonderful panels after lunch. But right now we have, please continue to enjoy your lunch, but we have our keynote speaker, Professor Robin West from Georgetown, and she's going to talk to us about contract as a civil right. So please welcome her. Jennifer, can I close this? Can I just close this? Okay. Is that doing it? Is that good? Okay. So the right to contract is my topic. Now, the right to contract, whether we view it as originating in the Constitution and common law or in natural law, is widely felt to be in tension with our civil rights broadly conceived. The individual himself, we generally believe, and only the individual, should decide the scope and the terms of his affirmative, voluntary, and other regarding undertakings, and when he does so through contract, the individual and only the individual should determine the terms under which he will perform those duties. The civil rights laws of both the 19th and 20th and early 21st centuries and the various rights they create seemingly interfere with these natural freedoms. So, for example, our freedom to hire whomever we wish to hire and then to fire them at will is compromised by our obligations under the Civil Rights Act of 1964 to not discriminate against candidates for employment or for promotions on impermissible grounds such as race, sex, ethnicity, age, or disability, at least according to early critics of those acts. We no longer have the right to contract for employment with whomever we wish and on whatever terms we desire because of the impact of those laws. Likewise, our freedom to sell or rent our home to whomever we wish is compromised by the civil rights of others to not suffer discrimination in housing or rental markets. Again, we do not have the right to contract for the sale, purchase, or rental of our property with whomever we wish and on whatever terms, and we do not have such a right by virtue of civil rights laws. Similarly, our right to contract for the sale of our labor, for whatever wages for which we can bargain on whatever terms we manage to strike, is seemingly compromised by what are widely viewed as civil rights to a minimum wage and fair working conditions enforced by various legal regimes coming out of the New Deal, and more recently various entitlements flowing from the Family and Medical Leave Act, which also substantially altered terms of employment contracts, regardless of the will of the contracting parties. That act as well, then, is widely understood as protecting civil rights to non-discrimination against parents or caregivers in the workplace. So all of these civil rights presumably either prevent some labor contracts from being consummated at all, or they dictate the terms of those that do come to fruition. To take one further example, our felt right to contract only when we voluntarily consent to do so and to refuse to contract whenever we so desire is compromised by our newly crafted obligation under the Affordable Care Act to purchase health insurance, an obligation clearly aimed at ensuring to all Americans a secure civil right to health care. So again, the natural right to contract or to not contract seems to be badly compromised by this new civil right to health care, as neatly captured and then popularized by the reductio argument employed by various advocates and Supreme Court justices both, that mandating the purchase of health insurance, as the Affordable Care Act tries to do, is tantamount to ordering all of us to go to the store and purchase a head of broccoli. If the individual mandate is required by a broad civil right to health care, the argument goes, then that civil right, too, is in tension with our right to contract. More generally, or more abstractly, our natural right to contract is seemingly in conflict not only with our civil rights laws, but also with at least some very general obligations of civil society, such as, for example, the duty to help others if such help can be given without undue hardship, or our various duties, whether legal or moral, to assist family members, neighbors, or co-citizens solely by virtue of close relational affinity. At the root of both this more general tension, as well as the root between the tension between contract and the rights flowing from our various civil rights acts, I believe, is a modern sense that our obligations today should flow solely from voluntary acts of consent and not from either duties of benevolence or from our membership in civil society, any more than they should follow from our membership in a clan or tribe or family or neighborhood. When we moved so famously from status to contract as the font of legal obligation, we have come to believe, perhaps, that we shed not only the obviously noxious sources of non-voluntary obligations, such as enslavement or gender or marital status, but more benign ones as well, such as membership in a civil society that is committed to such social projects as the racial and sexual integration of our workplaces and schools, or the health, safety, education, and well-being of all citizens. Our obligations today, we tend to think, should stem from what we have agreed to do, and not from what or who we are, including not only our race, gender, class, and so forth, but also apparently our civil identity. From within the logic of our commitment to contractual freedom, civil society and its projects, including the project of achieving some measure of racial or sexual justice, is just not the source of obligation any more than race, class, or gender itself should be. Rather, contract is a source of obligation, and to the extent civil society and the civil rights obligations that partly constitute civil society impose obligations outside of contract, those obligations are felt to be in tension with contractual freedoms and rights. So, in these comments today, I want to resist that argument I just gave you. I want to resist that tension. Thus, I will ultimately argue that the felt tension between a right to contract on the one hand and civil rights on the other, as well as the tension between the idea of contract and the obligations of civil society, although plenty enough real, rest on an unduly narrow conception of both the idea of contract and the idea of civil rights. The widely shared understanding of a right to contract as delineating a separate sphere of unadulterated individual sovereignty within which the state may not intrude comes to us, I will suggest in part, from the now discredited constitutional jurisprudence of the Lochner era. And although the constitutional law from that era is no longer good law, as is widely conceded, we do not today have a constitutional right to contract that gives us full sovereignty over whether, with whom, and on what terms to contract. Nevertheless, our contemporary general understanding of both what the natural right to contract is and what the constitutional right should mean, or what it could mean, or what it would mean if only we had one, or perhaps what it will mean if we ever get a court that gives it back to us, all of that is heavily determined by that constitutional jurisprudence. Thus, the felt contemporary meaning of the idea of a right to contract, and which is in such tension with the Civil Rights Acts and other obligations of civil society, is largely, I believe, an overhang from a discarded constitutional jurisprudence. The meaning that jurisprudence has given us, however, of the natural right to contract was never discarded. What we left behind was simply the faith that the Constitution protects it. So the Lochnerian meaning of the right to contract is not, however, the only possible social meaning of that natural right available to us. Lochnerian jurisprudence is not the only historical context in which a natural right to contract has played a role in our positive and fundamental law. A very different understanding of both the content and the meaning of the right to contract, I will argue, comes from the civil rights traditions themselves. So, civil rights. Civil rights are widely understood today as meaning roughly rights of non-discrimination. Our civil rights are taken to be our rights to not be discriminated against on the basis of various characteristics. This is the understanding of the phrase civil rights that is in tension with our understanding of the natural and Lochnerian era constitutional right to contract. But that understanding of civil rights as anti-discrimination rights is clearly inadequate, and for two reasons. First, our civil rights over the century that we have been using that phrase have included a number of rights, such as free speech rights, rights to the protection of the state against private violence, labor rights, union rights, and these days rights to health care or rights to affordable health insurance that have little or nothing to do with discrimination. So civil rights are clearly not only anti-discrimination rights. But second, and more to my point here, even those civil rights that do target and then prohibit discrimination do not do only that. Rather, and as the Civil Rights Acts of both the 19th and 20th centuries make clear, the civil rights of which we cannot be discriminatorily deprived by virtue of those laws include notably rights to contract, rights to own and sell property, rights to make a will, rights to testify in court, rights to sue for injuries wrongfully inflicted upon us, and rights to be protected by the state against private or public acts of violence. Those are civil rights too. Thus, our civil rights include not only rights to be free of discrimination, but also a number of common law rights, including rights derived from the common law legal regimes of contract and property law, of which we cannot be discriminatorily deprived. The right to contract, then, whatever its status as a constitutional right, is clearly a civil right, and has been since it was declared as such in the Civil Rights Acts of the mid-19th century. So what is the nature of the right to contract? Understood now not as a Lochnerian right of individual sovereignty, but instead as one of a number of civil rights, and of which, according to our civil rights laws, we cannot be deprived. I will argue in a moment that the civil right to contract is quite different from the constitutional right to contract, as it was defended by the Supreme Court during the Lochner era, and which continues to have such an impact on our political imaginations. The civil, rather than the constitutional right to contract, has a different historical pedigree. It rests on a different jurisprudential conception of the point of contract, and it stands in a very different relation to the civil society from which it originates. And finally, when understood as itself a civil right, the right to contract is clearly not in conflict with our civil rights laws in toto, or with more general obligations of civil society. Rather, the civil right to contract is fully consonant with our statutory civil rights, both to non-discrimination and more broadly conceived. In fact, far from limiting the civil right to contract, our civil rights in toto, both the 19th century ones and the modern ones, quite dramatically extend and deepen it. So, in the first part, in a moment, I will delineate what I believe to be the still dominant and quasi-constitutional conception of the natural right to contract as it has been understood, at least from the Lochner era to today. In the second, I want to contrast that Lochnerian constitutional right to contract with the civil right to contract. In the third, I want to show that the civil right to contract is fully consistent with modern civil rights laws, broadly understood. In the fourth, which I might skip, I'll explore the relationship between the civil right to contract and civil society, where I will suggest that rather than being in tension with it, the civil right to contract is one of the core and perhaps the core architectural foundations of civil society, and then I'll briefly recapitulate. So, the natural right to contract and its constitutional origins, this is familiar, I'm going to go fast, but I'm going to call this familiar understanding of the right to contract with which civil rights laws in particular and civil society in general are in such apparent tension, a self-sovereignty conception of the natural right to contract. So on this view, the right to contract is a natural or pre-legal right that confers sovereign authority on the individual with some limited and delineated sphere to decide whether, with whom, and under what terms to enter contracts. Those contracts then become the source of other regarding obligations. So the right to contract, so understood, dictates a sphere of sovereignty within which the individual is, so to speak, in full command of his obligations. Within that sphere, the individual is unencumbered by other, and particularly more civic, obligations. The boundaries of his or her contractual obligations on this view thus determine not only what she must do as she promised, basically, but also what she need not do outside of her duties to refrain from harming others. Her legally binding obligations to affirmatively assist others are determined by no source of authority other than her own will. This is simply what it means to have a right to contract. If that's correct, then the obligations imposed on all of us by our various civil rights laws are indeed at right angles with the right to contract in at least three distinct ways. First, if individual sovereignty is the point of the right to contract, an individual cannot be required to contract with any particular person or firm or to bind himself to any particular terms. He must be free not to contract, whether for good reasons, bad reasons, or no reasons. A requirement to contract with particular partners or on particular terms is logically oxymoronic as well as politically obnoxious. This is the source of the tension between our felt contract rights and both anti-discrimination rights in employment and housing and New Deal-style labor rights, such as rights to a minimum wage, decent working conditions, and so on. Second, if the point of the right to contract is individual sovereignty, an individual cannot be required to enter into a contract, no matter who it's with and no matter what the terms, whether for his own good or in furtherance of a larger social or communitarian goal. A mandatory contract, then, is simply oxymoronic as well. At common law, for example, as expressed in a number of iconic cases, an individual, even a professional, cannot be obligated to come to the aid of another person, even with an expectation on both sides of eventual payment. No one can be required to enter a contract to come to the assistance of another person. Exceptions to that rule are few and far between. Contract is the source of obligation once entered into, but the assumption of the obligation must be entirely voluntary. This is the source of the tension, then, between contract rights and the insurance mandate in the Affordable Care Act, or the tension between the idea of contract rights and the hypothetical state directive invoked by the Chief Justice as well as others, to buy broccoli, or Scalia, I guess. Third, somewhat more ambitiously, on the self-sovereignty conception of the right to contract, an individual cannot be imposed upon to provide aid or assistance to others outside the realm of his contractual consensual undertakings, beyond those obligations not to harm that are imposed by criminal law or a narrowly drawn law of tort. This is what it means to move from status to contract, and this is the source of the tension between contract rights on the one hand and the obligations of civil society on the other, including both the various statutorily imposed obligations to assist others and any legally enforced duties of generalized benevolence. This larger conflict is perfectly captured in a pivotal scene in The Great Gatsby, when the wealthy, old-moneyed Tom Buchanan explains to his car mechanic, George Wilson, that he, Buchanan, does not have to sell Wilson his car, and if he chooses not to, Tom explains, he owes Wilson, quote, no obligations whatsoever, unquote. If there's no contractual obligation, there's no obligation whatsoever, as Tom says, and whether or not there is a contractual obligation is within the domain of self-sovereignty. As Tom explains to George, in the absence of contract, Tom owes George nothing. All that he might owe him, conversely, is what he has promised, or perhaps what he would have promised had transaction costs been low enough to facilitate a contract, our post-status to contract understanding of the meaning of tort obligations. Contract, either real or hypothetical then, exhausts the realm of obligation. So where did the self-sovereignty conception of contract as conferring absolute rights on the individual to determine whether, with whom, and on what terms to contract, and then limiting our obligations to those promises come from? Obviously, the right to contract so understood, and that seemingly conflicts with both our civil rights laws and with the obligations of civil society, is not a purely legal construct. It did not come, for example, from the common law of contract. The common law courts have, after all, found occasion to fashion quasi-contracts that impose mandatory contracts on parties who have not consented to them. It has constructed terms requiring good faith, lack of duress, substantive conscionability in all contracts, regardless of the party's consent, and it has even deigned to dictate who may and who may not enter contracts. Those over the age of majority, but not those under, those who are deemed competent, but not those who are not, and so on. The individual sovereignty conception of contract cannot be pinned on the common law. So where did it come from? Well, so one possibility is that this popular American conception of a natural right to contract that preserves the sphere of self-sovereignty is rooted in this relatively short-lived history of a constitutional right to contract, once recognized by the Supreme Court as protected by the Due Process Clause of the 14th Amendment, and which reached its high point in the early 1900s in such cases as Lochner v. New York. In those cases and in that era, the individual right to contract protected by the Due Process Clause of the Constitution did indeed protect an individual's pre-existing natural liberty or right to decide whether, with whom, and on what terms to contract, and to thereby assume other regarding obligations. That constitutional right to contract no longer has much, if any, constitutional significance. It was effectively gutted by the constructive reversal of Lochner and West Coast Hotel, and then in the court's repudiation of the laissez-faire and radically individualistic assumptions in subsequent decades. Thus, it is now universally understood it is not only within the police power of the states to modify contract terms, to dictate to some degree with whom one may and may not contract, and to require some contracts, such as automobile insurance contracts, as conditions of privileges such as driving, and to bar entirely other contracts, such as contracts for prostitution, gambling, or surrogacy arrangements, as contrary to public policy. But that it is also within the Commerce Clause power of the national government to regulate contracts as well, so long as those contracts in some way affect interstate commerce. Civil rights obligations fit squarely within the contours of this reformed post-Lochnerian constitutional jurisprudence. We are precluded by virtue of those laws from contracting for housing or labor with whomever we please and on whatever terms we can rest. Thus, we don't now have, if we ever had, an absolute constitutional right to the contractual sovereignty that I described at the outset. We have no constitutional right to refuse to enter contracts that have been mandated by the state, or to hire only white people or men, or to include in those contracts onerous contract terms that violate states' norms of unconscionability, public policy, good faith, and so on. Our contemporary understanding of the content and meaning of the natural right to contract, however, is still strikingly Lochnerian in its content. We just don't think the Constitution protects it any longer, at least in as robust a fashion as it once did. But we still tend to mean by that phrase a natural right to determine whether, with whom, and on what terms we will take on other regarding obligations, and that in turn determines a sphere of freedom into which the state may not intrude. More briefly, we still more or less mean by the phrase a right to contract that the individual will, and only the individual will, is the source of other regarding obligations. That social meaning of the right to contract is as dominant today, both in popular consciousness and in academic discourse, as it was then dominant in the aughts, teens, and 20s in constitutional law. The individual sovereignty conception of the right is, for example, reflected in this resurgence of Ayn Randian-styled militant anarchism in popular culture, from the newfound cult stature of those novels themselves to its many more benign cultural reinterpretations, from the Fantastics to 24 to the Hunger Games. In all of those, as in Atlas Shrugged, personal bonds and only personal bonds, individually willed, rather than civic obligations of any sort, constitute the floor, and it's a very thin floor, of social obligation. It's echoed in the rise to power of the Tea Party within the Republican Party with its glorification of contractual freedom, its radical repudiation of civic society, and its movement's leaders, Rand Paul's, explicit repudiation of the moral authority of the Civil Rights Acts themselves, with the cited ground being that those acts limit individual contractual freedom. It is vividly and ominously reflected in Roberts' extended discussion, albeit in dicta, of the failure of the Affordable Care Act's individual mandate to pass constitutional scrutiny under the Commerce Clause. The mandate, Roberts opined in that decision, does not sufficiently affect commerce so as to be within the power of Congress to pass. Why? Because it requires individuals to do something, namely contract, rather than simply forbidding them from acting in a particular way. That, he argued, citing virtually no positive legal authority whatsoever, simply goes too far. That, we might surmise, precisely by virtue of the absence of such reliance on positive law, violates a natural right of individuals to decide whether to contract. It violates that sphere of individual self-sovereignty, and that violation in turn determines the limit into which the Commerce Clause-based authority of the federal government may not reach. In academic discourse, the dominance of this self-sovereignty understanding of the right to contract is vividly reflected in the multiple reinvigoration and positive reassessments of Lochner-era jurisprudence that have fruitfully challenged the conventional post-Lochner consensus within the Academy over the last decade. And finally, it is most cleanly reflected in the contours of the most developed jurisprudential conception of contract and of the moral point of contract, that contract rightly valorizes both the individual act of consent and individually dictated consensual transactions, such that for deontic Kantian or just loosely libertarian reasons, all consensual transactions are regarded as of value solely because of their consensuality, and alternatively, that contract rights and contract law rightly maximize social wealth by encouraging individual acts that promote economic efficiency. Both the libertarian or Kantian understanding and the related economic or efficiency-based understanding reflect as well as rest on a self-sovereignty conception of the right described above. Individual consent and wealth maximization both are furthered by the self-sovereignty at the heart of the natural right to contract, and both are compromised by limits on that sovereignty. It is that social meaning of the right to contract that is in felt tension then with the obligations attendant upon us by virtue of the Civil Rights Acts and the duties imposed upon us by civil society. Okay, now second, I want to contrast all of that with the civil right to contract. So the question then is this neo-Lochnerian understanding of the right to contract the only understanding available to us? And I think not. As I noted above, a very different understanding of the right to contract can be derived not from our constitutional history, but from the history of the civil rights themselves. The right to contract, well before the Lochner-era court enshrined it as a constitutional right, was understood not as a limit on civil rights, but as itself a civil right. It was, that is, understood to be one of a number of such rights guaranteed to us under various civil rights laws passed into law by the Reconstruction Congress on the heels of passage of the 13th and 14th Amendments. The right to contract understood as a civil right, like rights to property and other civil rights, such as the right to physical protection from the state against violence, or the right to sue in court for injuries we sustained, cannot be denied because of race. Thus, to quote from the Civil Rights Act of 1866, "And such citizens of every race and color, without regard to any previous condition of slavery or involuntary servitude, except as punishment for crime, shall have the same right in every state and territory to make and enforce contracts, to sue, be parties, give evidence to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of the person and property, as is enjoyed by white citizens," etc. Again, then, the right to contract, according to the framers of the Civil Rights Act, along with the right to own and sell property, right of will, sue for injuries, give testimony, and so on, are all rights that cannot be denied on the basis of race. Freed slaves must have the same right to enter contract, own, buy, and sell property, sue for injuries as whites, or at least as white men. The right to contract in this context is one of the civil rights of which we cannot be deprived on account of impermissible characteristics. Indeed, it was one of the original cluster of such rights of which we cannot be deprived for impermissible reasons. The right to contract is clearly a civil right. How might our understanding of the right to contract change if we were to think of that right again as a central civil right rather than as a natural right fitfully protected by constitutional guarantees? It depends, of course, in large part on what we mean by the phrase civil right. So I've written about this recently at length elsewhere, and I'll just summarize it here. As noted above, we tend to think these days of civil rights as rights of anti-discrimination, but that's inadequate for reasons that bear repeating. First, a number of what we commonly call civil rights, such as labor rights, free speech rights, rights of criminal defendants, are not rights of anti-discrimination at all. But second, even the civil rights of anti-discrimination protect us against underlying civil rights of which we cannot be discriminatorily deprived. Thus, we arguably have a civil right to marry, of which we cannot be deprived on the basis of sexual orientation. We have civil rights to be considered fairly for a job, of which we cannot be deprived on the basis of race, gender, etc. And of course, we have civil rights to contract property and to access to the courts, of which we cannot be deprived by discrimination. Our anti-discrimination rights are always, that is, complex. They are, in effect, rights to rights, with the first right in the phrase right to a right being the anti-discrimination right, but the second right in the phrase a right to a right being the civil right of which we cannot be deprived. And the right to contract is one such civil right. It is a right of which we cannot be deprived on the basis of race, sex, etc. The right to contract itself, then, is a civil right and has been recognized as such since at least 1866. So what is a civil right? Civil rights, in turn, have been defined, at least since Tom Paine's iconic account in his pamphlet, Rights of Man, as natural rights, but a particular kind of natural rights. Civil rights are those natural rights which we have not only by virtue of being human, this is true of all of our natural rights, but also civil rights are rights by virtue of our membership in civil society and which we cannot enforce on our own. That's my paraphrase. Paine's language is this: natural rights are those rights which appertain to man and right of his existence. Of this kind are the rights of the mind and also those rights of acting as an individual for his own happiness, which are not injurious to the natural rights of others. Civil rights are those which appertain to man and right of his being a member of society. Every civil right has for its foundation some natural right pre-existing in the individual, but to the enjoyment of which his individual power is not in all cases competent. Of this kind are all those which relate to security and protection. So, the definition of a civil right, according to Tom Paine, is threefold. A civil right is first a natural right, meaning it's a right we have by virtue of being human. But second, it's a particular kind of natural right. It's a natural right which we enjoy by virtue of being a member of society. And third, unlike, say, rights of conscience, it's a natural right which we cannot enforce on our own. The individual power is not in all cases competent. Put positively, a civil right is a right to participate in civil society and which requires the presence and operation of positive law for its realization. It requires, in other words, the presence of law in legal institutions rather than their absence. Civil rights are, in this limited sense, quintessential positive rights. They are rights to the operation of law in the state in such a way as to realize the individual's enjoyment of the underlying good or status or sphere of life that the right aims to ensure. So if civil rights are, as Paine argued, natural rights that we have by virtue not only by being human, but by virtue of membership in society, and those which we cannot enforce on our own, and a right to contract as per the drafters of this country's original civil rights law is itself a civil right, which must be extended to everybody, then what is the right to contract when understood as a civil right? Obviously, the most direct effect of the inclusion of the right to contract in the 1866 Act is that the contracts of African Americans must be enforced in the same way and to the same degree as the contracts of white men and women. But what is the meaning of the right to contract that must be accordingly enforced? What is the point, to borrow from one of Ronald Dworkin's most evocative metaphors, of this civil right to contract that must be so extended? How might it differ from the conception of a right to contract as a constitutional right as described above? First, the civil right to contract, like all civil rights, is a natural right on the Paynian conception, by which Paine meant a right that attaches by virtue of one's humanity, but which we might today interpret in more modern terms, borrowing from Sin and Nussbaum's naturalist account of human rights, that the right is in service of natural human capabilities that are conducive to a good and flourishing life. Human rights are those rights which protect or further our capabilities, which in turn enable us to flourish. The kind of human interaction manifested in contract is both a capability of human beings and it's one that contributes to human flourishing. But second, per Paine, the right to contract is a distinctive kind of natural right. If Paine is right about the meaning of civil rights, and if the framers of the 1866 Act were right, that were correct, that the right to contract is a civil right. The right to contract is a right we have by virtue not only of our humanity, but by virtue of membership in civil society. Contract in the capacity to engage in it, in other words, is a creation of civil society. It is not an implication of our human form alone. Like our other civil rights, the right to contract then is a right of participation, or as I've elsewhere called civil rights, rights to enter rather than rights to exit. It is a right to participate in civil society. It is a right at heart to be included in that which society facilitates. So more specifically, with respect to the civil right to contract, it is a right to participate in the society that is constructed more or less by contracts. So we have a natural right to exchange money or goods for other goods or services because such behavior furthers our individual capabilities for living fruitfully. But that is a natural right that can only be realized through markets that are structured by law and institutions. The laws enforcing contracts, but also laws and institutions specifying rights and parameters of ownership, of fair dealing, and of criminal law. The civil right to contract then guarantees us access to those laws and institutions that structure our markets for consumer goods, protecting our participation in those markets. But markets for consumer goods, obviously, is not the only area of civil life that contract facilitates, and participation of those markets is not the only right that the right to contract confers. The civil right to contract also, for example, protects a right to participate in markets for labor, and markets for property, and markets for the pooling of risks through insurance contracts. Those markets, in turn, serve human needs and capabilities that are also themselves both natural in origin and civil. We have a natural capability to enjoy meaningful work, but we need civil society in order to protect that capability. We need access to the laws and institutions that structure a workplace that rewards labor and provides meaningful floors of compensation and safe working conditions. We access those laws and institutions in this society through contracts for labor. A right to contract, then understood as a civil right, protects our ability to access those laws and institutions that structure the fair and meaningful labor we have a natural right to enjoy. Likewise, we have a natural capability to live a long and healthy life, according to Nussbaum and Sen, but we need civil society to protect that capability. We won't live long and healthily in a state of nature. Rather, we need laws and institutions that can generate medical knowledge and expertise, as well as its distribution through networks of provisions of care. We access those laws and institutions in turn in this society through contracts. Contracts with doctors and hospitals, obviously, but more fundamentally, contracts with insurers who in turn pool risk. We have a civil right then to access those networks, and thus a civil right to participate in the pooling of risk that's facilitated by insurance policies, itself accomplished through contract. Thus, we have a civil right to contract for health insurance. Likewise, we have a natural capability to enjoy property and the security and pleasures it bestows, but we need civil society to protect that capability. We need both the laws and the institutions of private property and criminal law to generate the protections and securities of individually owned property. We have a civil right then to access those laws and institutions, and the way to do so in this society is through contract. Our civil right to contract then guarantees us, in part, rights of access to those laws and institutions that structure and protect property and its enjoyments. Second, and again according to Paine, the civil right to contract, like all civil rights, is one that cannot be effectuated by man standing alone. It is, in its essence, a right the enjoyment of which is entirely dependent upon social forms. It is, in other words, a profoundly social construct. It requires societal construction, constraint, and enforcement. It is not something that exists in the state of nature. It is a product of, as well as a mainstay of, civil society. The point of the right, then, cannot be to protect a natural pre-civil sphere of individual sovereignty that exists independent of the state or of state law. No such sphere exists. We would not be contracting in such a state. The civil right, again, is one we enjoy not only by virtue of our membership in civil society, but it is one we cannot perfect on our own. The point of the right, then, is to protect our participation in this thoroughly civil sphere of bargain and exchange. So let me put all this together. The civil right to contract, unlike the constitutional one, is not at heart a right to self-sovereignty. Rather, it is a right of participation. It is a right to participate in markets of various sorts that are themselves conducive to human flourishing. It is a right to enjoy access to the benefits and the goods facilitated by those aspects of civil society that are structured by contract. And there are clearly several such aspects. First and most directly, the acts of barter, exchange, and bargain, the sale and purchase, for example, of consumer goods, is a human activity that is itself social and civil, and the right to contract is a right to participate in that social and civil form of activity. The civil right to contract, then, is a right to participate in markets of exchange. Contract also, though, is an activity that facilitates other forms of social and civil life than those represented by simple bargains, and the civil right to contract, therefore, is a right to participate in more complex forms of social and civil life as well. Contract facilitates, for example, cooperative enterprises that can lead to not only more complex, but also more rewarding forms of living. The enjoyment of private ownership of real property is one such form of life, facilitated by property and property law, to which the civil right of contract grants access. Similarly, contract facilitates participation in the legal and institutional structures of employment. Those structures, in turn, contribute to both individual security against want, as well as social enjoyment of the products of cooperative labor. The civil right to contract is a right to participate in that world of employment. Contract facilitates the pooling of life's risks, both catastrophic and mundane, such that when those risks come to pass, they can be weathered more smoothly. That pooling of risk, in turn, leads to better health care and hence better health outcomes, meaning longer and healthier lives. It facilitates cooperative action in all of those spheres, markets, property, employment, and health, that might otherwise be precluded by familiar prisoner's dilemmas, thus increasing well-being all around. In all of these spheres, then, contract facilitates a sharing of excess value that otherwise tends toward either a winner-take-all or worse outcomes for all set of outcomes, increasing inequality and subordination both. Rights to contract, then, serve social and civil values and not just individualistic ones. Okay, so contract rights now and civil rights. The rights protected by the Civil Rights Acts, yes, that's fine. The rights protected by the Civil Rights Acts, both those of the 19th and 20th centuries, are not in tension with the right to contract if we understand the latter as a civil rather than a natural constitutional right, and if we understand civil rights as including not only non-discrimination rights, but as also including the rights of which we cannot be discriminatorily deprived. Again, the conflict between civil rights and contract rights stems from viewing civil rights as simply anti-discrimination rights, and contract rights as quasi-constitutional or natural rights of individual self-sovereignty, delineating a sphere within which the individual has sole authority to determine whether, with whom, and on what terms to assume other regarding obligations. But this rests on a misguided understanding of the idea of contract rights and the idea of civil rights, both. Civil rights are not simply rights against discrimination, they are rather rights of participation. They are rights to participate in the spheres of social or civil life that are themselves facilitated by law and civil institutions. The right to contract, then, is not just a natural and constitutional right to self-sovereignty, it is also one such civil right. And as such, it confers a right to participate in markets for, among much else, consumer goods, employment, insurance, and real property. Civil rights, in brief, are rights of access to civil society. Contract rights are rights to participate in those aspects of civil society that are facilitated by private contract. Contract rights, then, far from being in tension with civil rights, are themselves civil rights, and as such, they protect access not only to consumer markets, but to other civil rights, such as rights to property, employment, education, and health care as well. So civil rights are contract rights, and contract rights are themselves civil rights. The civil right to non-discrimination in employment protected by Title VII does not fundamentally limit contractual freedom when the latter is understood as a civil rather than a constitutional right, but rather it clearly expands it. Rights to non-discrimination in employment are rights to participate in a sphere of contractual life that facilitates the provision and compensation of labor in ways that in turn further the individual's interest in security and the societal interest in the enjoyment of the products of cooperative labor. Title VII rights against discrimination in employment are themselves simply a special kind of civil contract rights. They are rights to contract in a literal sense. They extend the right to contract for one's labor to those who had previously been excluded from enjoying it. But they are also contract rights more broadly understood. They guarantee participation in a sphere of life, employment, that is itself structured through contract, and that collectively promotes individual well-being and individual capabilities for meaningful and dignified work. Civil rights guaranteed by Fair Housing Acts are likewise not in tension with contract rights. Rather, those civil rights are themselves contract rights. They are rights to participate in markets for the enjoyment, sale, and purchase of property, themselves facilitated by contract. The right of non-discrimination in employment and housing then no more limits the right of contract than does extension of the right to vote limit by diluting the power of the voting rights of those who already possess them. Participation in markets for employment and property is central to civil society. They are rights we have to echo pain by virtue not only of our humanity, but by virtue of our membership in that society. Guaranteeing that participation broadens and deepens the right to contract. It doesn't limit it. The right to affordable health insurance guaranteed by the Affordable Care Act likewise are not limits on the civil right to contract. Rather, they are themselves civil contract rights. The right to insurance is, after all, not a right to health per se, but a right to a particular kind of contract. It guarantees the right to participate in the pooling of risk of ill health that makes the forbearance of medical illness less financially catastrophic. The Affordable Care Act then guarantees that everyone, and not just people with secure employment or with considerable private resources, has access to that particular form of contract and the relative security against risk to which it gives rise. Like Title VII or the Fair Housing Act, it thus expands, it doesn't shrink, the civil rights to contract. And to take one final example, the Family and Medical Leave Act, which requires employers to provide unpaid leave for their employees with newborns or other family members requiring care, clearly alters the terms of employment contracts in ways that might not have been willed by both parties in the absence of law. Nevertheless, it just as clearly expands access to the civil right to contract. It makes it possible for new parents of infants or grown children of elderly parents to continue their employment uninterruptedly, thus maintaining their presence in the contractual world of work. Contract opens the doors to the world of employment. The Family and Medical Leave Act ensures that those doors remain open even after the birth of a child or the sickness of a parent, events which, in the absence of the law, can cause a breach in the contractual and interactive world of employment because of the urgency or the priority of the private and intimate world of caregiving. Like anti-discrimination laws, then, and like the Affordable Care Act, the Family and Medical Leave Act expands participation in the world of contract and the complexity, security, risk pooling, interactivity, and enrichment that contract facilitates. Thus, the civil rights protected by the Civil Rights Acts, as well as those protected by the Affordable Care Act and the Family and Medical Leave Act, are not in conflict with the right to contract, if by the latter we mean the civil right to contract. The civil right to contract is a right to participate in the spheres of life largely structured by contract and contract law, the sale and purchase of consumer goods, real property, insurance, employment, higher education. The Civil Rights Acts of both centuries, the Affordable Care Act and the Family and Medical Leave Act, all broaden and deepen participation in those spheres of life. They therefore broaden and deepen participation in contract. The civil right to contract, understood as a right to participate in the civil forms of life made possible by contractual behavior, then is strengthened and not undermined by the civil rights laws of both the 19th and mid-20th centuries. Now, what of the last conflict that I noted at the outset? The conflict between a right to contract on the one hand and the duties and obligations of civil society, including possibly affirmative obligations to help others if we can do so at no or little cost. Was Tom Buchanan right in The Great Gatsby to callously inform George Wilson that he, Tom, did not, after all, have to sell his car to him, and that if he did not, he would owe him no obligation whatsoever? Does contract so exhaust the realm of other regarding obligations that we are never obligated to provide assistance outside of our contractual and voluntarily assumed duties, which we are never obligated to assume in the first place? Does the movement from status to contract obviate obligations stemming from our status as members of a civil society? It may indeed, if we regard contract as described above as a natural or quasi-constitutional right to decide when, with whom, and on what terms to assume other regarding obligations. But it may not if we regard the right to contract as a civil right protecting rights of participation in contractual life, rather than as either a natural or constitutional right protecting a private and individual sphere of sovereignty. The civil right to contract is a right to enter those spheres of civil society largely regulated by contract. The right itself, though, is fully a product of that civil society, and the world to which it guarantees entrance and participation is likewise a product of civil society. The civil right to exercise contractual authority, then, can exist side by side with other civil rights and obligations, including obligations to extend help to others, if such obligations originate in civil society itself. Whether or not they do is another question, but if they do, the existence of robust contract rights does not stand in tension with them. So by conclusion, still doing just fine. Okay, so I've tried in this paper, in this talk, to work out the implications of a straightforward syllogism. The right to contract, according to the drafters of the 1866 Civil Rights Act, is a civil right of which we cannot be deprived by discriminatory action. And civil rights, at least according to Tom Paine, who gets quoted on this more than any other author. So civil rights, according to Tom Paine, at least since this country's beginnings, are those natural rights we have by virtue not only of our humanity, but also of our membership in civil society, and which we cannot perfect on our own. The right to contract, then, is a civil right, is a natural right we have by virtue of membership in civil society, and which we cannot perfect on our own. Like other civil rights, it is a right to belong, or a right to participate in that civil society or those parts of civil society to which contract gives access. And what parts of civil society are those? Contract structures the public worlds of employment and healthcare and higher education and commerce. We enter the workforce, schooling, commercial markets, and healthcare through contracts. Contracts of employment, of enrollment, of sale and purchase, and of insurance. And those worlds to which contract gives entree make our lives better in familiar ways. Employment gives us security against want, as well as meaning in our productive lives. Schooling enriches and complexifies our lives and improves our chances for success. Commerce and commercialism give a source of pleasure as well as access to markets that can enrich us. And insurance allows us to guard against calamities by pooling risks with others. A civil right to contract then confers rights to participate in those worlds, and a civil right to contract free of discrimination simply extends those rights of entry, participation, and of belonging to those who had previously been excluded, either because of enslavement, discrimination, racism, sexism, etc. None of these contractual realms would be possible or even conceivable without the laws and the institutions of civil society. The civil right to contract ensures for everyone, not just those who are privileged, or those with whom others wish to deal, or those to whom Tom Buchanan deigns to sell his car, access to those institutions and to the benefits of the laws that constitute them that allow all of us to flourish. Thank you. Sure.
I like the way your argument's structured. Is what you're saying that contract is a construct of civil society, and therefore it sort of reflects the general interest of civil society? Is that a fair statement? If you heard it.
Yeah, I heard it. So the question was, is the thesis here that contract is...
Let me follow up what I'm saying. It seems to me like you're saying that civil rights are a construct of civil society. That civil society creates civil rights, like the right to contract. And those rights are created in the interest of civil society. And so my question would be, if that's the case, is there some ultimate standard? Because North Korean society protects a very different group of rights. You know, it protects your right as a member of the Communist Party to a job.
Right.
And so that seems to be kind of a thin conception of rights, because I think of some of the more fundamental rights as existing outside of civil society.
That's correct. And I think that that does in some ways go to the heart of it. What's interesting, I think, about Paine's understanding of what a civil right is that it's completely dependent, its existence is completely dependent upon positive law, right? So of course it's going to differ in these different societies, the content of it's going to differ in these different societies. That's the difference between civil rights on the one hand and human rights on the other, right? I mean, you may have a human right that could, in theory or in common morality, trump whatever Korea has to say about who does and who doesn't get rights in a communist state. But the civil right is I think what's interesting about his conception is that the civil right is a right that is completely dependent upon positive law. It's a construction not only of civil society, it's a construction of positive law. Positive law is the architecture of civil society, and that architecture is legal. I mean, I'm reading a lot into that short quote, but I think it's fair.
It is an interesting thing to think that people may have as a civil right the right to engage in the contractual market, and that could be part of the context in which other people thinking about abstaining have to operate.
Right. The point is very well taken. In other words, if there's anything left of the individual self-sovereignty conception of contract post the repudiation of Lochner, whether it's tied to the Constitution or not, then how will the civil right to participate in various contractually defined spheres of life interact with the, sort of more conventional understanding of an individual's natural right to contract out or to not contract? That's correct. That's the problem. What I've wanted to correct is the impression that it's not a fair fight, that it's all on the side of the right to opt out, to not contract, to decide just me, myself, and I, whether, when, and with whom I want to contract. There's nothing on the other side other than a bunch of sort of good policy ideas. And that, I think, reflects, first of all, a lack of appreciation of our history, but second, a lack of appreciation of the pull of civil society itself. I mean, there's been plenty, and lots of writing about civil society, but it's a sort of legally denuded body of scholarship. The word nude or naked keeps coming up in this conference, but that was just in one of the panels. But at any rate, so you have, plenty of people, bowling alone is the sort of paradigm, but it's an understanding of civil society that oftentimes takes it as being in opposition to law, right? You have civil society, that's something different from what law is. And so what I want to do is bring out a tradition within the civil society literature that ties all of this to positive law. But then more broadly, I just want to sort of elevate the status and the stature of civil society as the font of obligation, including obligations and rights of contract itself. And that, I think, is what's missing in the contract literature.
Any other questions? Wonderful. Let's thank Professor Black.
Thank you.